Hello, and welcome to California Gun Law. I'm your host, Don Hammond, with an update on Assembly Bill 1078. This bill just passed the state Senate yesterday and will be headed back to the Assembly for another vote before it heads to the governor's desk. The bill makes substantial changes to the CCW licensing process in California, creates a statutory framework for issuing non-resident CCW licenses, restricts firearm purchases to only 3 guns in 30 days. We'll dig into the details of what all this means. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss updates to Assembly Bill 1078. This bill passed the state assembly back in June, and after several amendments, it just passed the state Senate yesterday on September 9th, 2025. I know that many in the firearms community are staunchly opposed to this bill, and the Senate vote was straight down party lines, with all Democrats voting for it and all Republicans voting against it. I think there are some good things in the bill and some bad things in the bill. It would be ideal if these topics were broken up and voted on separately, but we all know that's not how government works. This bill does 3 primary things. 1, it amends the California CCW licensing process to include a defined process for processing non-resident CCW licenses. 2, it amends the disqualifying factors for granting a CCW license in Section 26202 and 26195 to include out-of-state issues, but also provides clarification regarding certain types of restraining orders. 3, it limits California firearm purchases to 3 guns every 30 days in pretty much direct defiance of a recent court decision. I'll go through each of these 3 key changes in turn and discuss what they mean. First, the changes to the California CCW licensing process include guidance for processing non-resident California CCW licenses. This law clarifies that all requirements can be satisfied either remotely or within 75 miles of the applicant's residence. This includes any psychological evaluation that the agency requires and the training and shooting qualification requirements. It requires non-resident applicants to list the guns they plan to carry in California and provides that the application can be denied if the listed guns are not legal to carry in California. So that could be an interesting area for future litigation. I don't interpret that as meaning that the guns have to be on the roster, but we'll see how the issuing agencies look at that, and then ultimately how the courts look at that. The bill also clarifies that when a non-resident application is denied, they can request a court hearing in the county where they applied to challenge the denial. In one recent hearing, the DA tried to argue that my non-resident client was not entitled to a hearing because he didn't live in California. Fortunately, the judge saw through that absurdity and ordered the sheriff's department to issue the non-resident CCW license. The second thing that this bill does, it clarifies the disqualifying factors for getting a CCW license in California. For 2 years, I've argued that failure to disclose information on the application is not a legal reason for denial. I even have a case up in the Court of Appeals on that issue. Now, this bill changes that and explicitly mandates that issuing agencies shall not issue a license if the applicant knowingly provides any inaccurate or incomplete information in connection with an application for a CCW license. That will be in the amendments to Penal Code Section 26195. We may have to litigate what a knowing failure to disclose looks like, but generally, if you don't put stuff on the application, it'll be legal to deny the application now. This bill also clarifies some of the disqualifying criteria in Penal Code Section 26202. It expands the disqualifiers to include out-of-state equivalents to several California convictions and restraining orders, which of course makes sense. If we're going to allow non-resident applicants, we need to look at their criminal history in other states, not just violations of California law. But the bill also clarifies that a temporary restraining order granted without notice and an opportunity for hearing is not disqualifying. This is important for several of my clients. Currently, any restraining order that exists within 5 years of an application is interpreted as disqualifying. So that's a big improvement. The third thing that this bill does is create a limitation on firearms purchases to 3 firearms in any 30-day period, which would take effect on April 1st, 2026. This flies directly in the face of the Ninth Circuit's recent court decision in Nguyen v. Bonta, which held that the state cannot meter a constitutional right. In that case, the court struck down California's 1 in 30 law that prohibited residents from purchasing more than 1 firearm in a 30-day period. The legislature appears to be in direct defiance of this court ruling. The court's language in Nguyen will apply just as squarely to the new 3 in 30 law as it did to the old 1 in 30 law. There's no historical analog that allows any metering of the right to purchase firearms. So the state's just buying another lawsuit. It'll spend millions of dollars of taxpayer money fighting another case that it will eventually lose in court. In the meantime, at least until there's an injunction, people will be restricted to purchasing only 3 guns in any 30-day period. In the current version of the bill, this restriction is set to take effect on April 1st, 2026. So get all your bulk gun purchases in before April so you don't really have to worry about it. Some people might ask, why would anyone need or want to purchase more than 3 guns at a time? Well, one response is, none of your business. But as an example, my wife and I are considering getting into cowboy action shooting. We bought 1 single action revolver, and if all goes well, we'll need 3 more so that we can each carry 2 for competition, plus we'll need lever action rifles and maybe some break action shotguns. I'd like to be able to purchase all of these things in one shot instead of being metered to 1 or 3 in 30 days. Now, I expect the Assembly to pass the amended bill pretty quickly, and then it'll go to the governor's desk for signature. Most of the provisions of the bill are expected to take effect on January 1st, 2026, and I have clients poised to take advantage of the helpful parts of the bill. I'm sure that CRPA and other Second Amendment organizations are ready to begin litigating the bad stuff as soon as it takes effect. I'm sure you have opinions about this new bill. How will it impact you? Let us know in the comments. And head on over to cagun.law for legal updates and to pick up some cool merch to support the cause. I'm Don Hammond at California Gun Law. We'll catch you all next time. Stay informed, stay legal, stay safe.